Thanks, Acting Speaker, and I rise today to also contribute to the Child Employment Amendment Bill 2022, and this is a very important amendment bill. After working 23 years as a trade union secretary, I find this bill very important in protecting our kids in their employment. Of course, the Andrews Labor government continues to ensure that the regulatory framework to protect Victoria's most vulnerable workers is strong and effective and important. The regulation of child employment is no exception. The Child Employment Act 2003 currently regulates when and in what circumstances children under 15 years in Victoria can work. And we know that part-time or casual work can have many positive impacts for children. Certainly, as the previous contribution from the member for Frankston about learning new skills, gaining some confidence, some independence, and also earning some money so the kids can purchase things for themselves, but also have some entertainment through that money that they earn. And of course, the benefits that they receive in their employment, this must be balanced against their educational development, of course, and the need for additional safeguards due to some vulnerabilities in the workplace. The Act sets out the age, types of work and conditions that apply to child employment and aims to protect children from doing work that could be harmful or affect their attendance at school and to protect children from exploitation. Of course, the age limits for child employment regulation in Victoria align with international labour standards on child labour. There was a review done on the Act in 2020, 2021, and the amendments proposed in this bill arise from that process. And as part of the review process, we consulted with employer groups, trade unions, industry associations, child welfare groups and other government departments and agencies. And that review certainly highlighted opportunities to improve the child employment regulatory regime, particularly with respect to streamlining the permit system and adopting a risk-based regulatory approach. And of course, the final amendments aimed to ensure that the Act and child employment regulatory scheme remains targeted, effective and responsive to contemporary workplace issues in changing the work landscape. This legislation does not propose to alter the minimum age for work, nor to displace a number of important exclusions. And the Act, under the current Act, employment of children under 15 years old is primarily regulated through a permit system, provided the employer obtains a general industry permit. Children aged 11 years and over can undertake delivery work, and children aged 13 years and over are able to be employed in other non-hazardous work. And certainly a research report identified that 6% of children under the age of 15 years are currently employed, and that 3.5% of Victorian businesses currently or have previously employed children under 15 years. And of course, the industries that these kids are working in mainly is in retail, I think around 35%, followed by food services, as we probably all know, in the fast food outlets, I think around about 21%, and then of course also in the entertainment industry. There's no minimum age for children to work in the entertainment industry, which can include performing, modelling, photographic, television, film work. But however, a specific entertainment industry permit is required. A mandatory code of practice further describes conditions around the employment of children in the entertainment industry where there may be risk are deemed to be higher. Certainly children of any age working in family businesses, as been referred before by previous contributions, including family farms, are exempt from the permit requirements. And children are only permitted to undertake light work and are excluded from employment in a number of hazardous industries and from performing dangerous tasks. And of course, we don't want our kids working in hazardous industries, and I would hope that those industries are not that hazardous, because we would hope that through health and safety they're made safe and not hazardous. So we certainly don't want our kids involved in any of those employment areas. These age limits for child employment regulation in Victoria are aligned with, as I said earlier, the international labour standards on child labour, and certainly Victoria's occupational health and safety laws also ensure that those children aged 15 to 17 years are afforded strong protection in their workplace. And certainly school attendance is compulsory for our kids in Victoria until the age of 17, with exemptions only granted in limited circumstances. Now, I've got a Melton Youth Forum, around about 8 to 10 kids that attend that forum on a monthly basis. All of them have some type of employment. A lot of them work in these fast food outlets. And one thing that they've requested of me is to run a local forum for kids to get to know what their rights are, their workers' rights are, because they have no idea of what their rights are. And they asked me a few questions as an ex-union secretary, and we spoke about that. They're all casually employed, of course, and we saw what happened with casual employees through COVID and the insecurity of casual work. And, you know, we talk about wages being kept down. Anyone that seeks to get a wage increase as a casual employee will not likely have contact from their employer the next day for the next shift, because clearly if someone wants to agitate for better wages as a casual, the employer can just not bother to ring you anymore. They don't have to terminate you, but they just don't have to ring you. So of course casuals unfortunately are kept under pressure to do work, to come to work sick, to not ask for wage increases, to do what the boss tells them to do. So these kids asked for a youth forum around these sorts of things, and this is what we're going to organise out in Melton later this year. But I will say on that, and it's pleasing to see the policy of the Andrews Labor government in regard to the sick pay guarantee for casuals, and it's been a fantastic policy introduction. And again, we saw through COVID how casual employees were affected and will continue to be affected in regard to going forward if they didn't have access to this sick pay, this 5 days of sick pay. What you see again is that you see that casual employees are forced to come to work because they need the money. They need to work, they need the money, they need to put food on their table, they need to enjoy themselves, they need to have social outings, they need to purchase things for them, and if they don't go to work, they don't get paid. So this sick pay guarantee is a fantastic initiative by this government. Of course, these kids in my youth forum enjoy working. They really do. They enjoy the experience. They enjoy getting paid for it because they want to use that money, as I said, to purchase things and have social outings and to also assist their family. A lot of them are from multicultural backgrounds that some of their money goes towards contributing to the family for food and things like that. So it's really important to them. So this current scheme requires an employer to apply for individual permits for each child they engage, and our review identified the permit system as one of the biggest issues for stakeholders who supported a more efficient, responsive and flexible approach. The bill introduces a streamlined child employment licensing system to replace the individual permit system, and it will simplify the process for obtaining permission to employ a child by requiring one licence application. And this is done annually for an entertainment licence and biannually for a general licence. So under the current Act, some employees who engage children frequently, such as those in the entertainment industry, can have hundreds of permits at one time, creating a significant amount of administrative work. The new licensing system will also enable better targeting of resources to focus on licence holders in the highest risk areas, who must provide more information and will receive more oversight, which might include increased emphasis on compliance and monitoring and audits. So employers will be able to employ multiple children under the one licence rather than applying for individual permits for each child employed. And they will then inform the WIV of each child who is employed, and there will be no cost associated with applying for a child employment licence. Of course, these measures will build on the Andrews Labor government's recent adoption of the new child safety standards, and to assure a focus by service providers and employers on children's safety and well-being. This Andrews Labor government will always stand up for workers and ensure protections exist, and this is another example of this government's ensuring that safe work environments exist and workers receive the protections that they need, whilst also streamlining processes for businesses. I support these amendments. I applaud the Treasurer and the Minister for IR and his staff, and I commend the bill to the House.